Good morning and good afternoon. Welcome, everyone. My name is Matthew Curtis, and I'm a partner here at Denton's in Toronto. Um, we look forward to joining for part 6 of our webinar series on navigating workplace investigation series. In Toronto, I advise Canadian and international organizations on a broad range of labor and employment matters. And joining me today are my colleagues, three colleagues across Canada. So my first colleague is Eleni Casares. She's a partner and leader of the Denton's Employment and Labor Group in Vancouver. Eleni has 20 years of experience advising employers on workplace disputes, investigations, privacy issues, human rights matters, occupational health and safety, labor and employment, and regularly represents employers before courts and tribunals and administrative bodies across British Columbia. With me as well is Christina Wendell, a partner and the leader of our Denton's Employment and Labor Group in Edmonton, as well as the leader of the Alberta Occupational Health and Safety Practice. Christina regularly advises employers on workplace investigations, harassment complaints, retaliation concerns, occupational health and safety matters, and labor and employment disputes. She's also a trained external workplace investigator with specialized trauma-informed investigation training. As well with me today is Stephanie Lewis, counsel in the Denton's Ottawa office. Stephanie is a highly experienced bilingual employment lawyer and advises employers on all aspects of the employment relationship, including workplace management issues, accommodations, performance management, investigations, and federally regulated workplace matters. So today's discussion focuses on topics that become particularly relevant as we move into the warmer summer months. Client events, conferences, offsite meetings, and informal social gatherings can create situations where workplace boundaries become less clear and where employers face increased risk of complaints, misconduct allegations, and complex investigations. Workplace investigations, as many of you know, are today no longer a simple fact-finding exercise. Employers have to navigate issues such as procedural fairness, delay, retaliation concerns, and reputational risk, all while ensuring that the process remains fair, defensible, and capable of withstanding scrutiny. Our panel will share practical guidance on where investigations commonly can go off track and how employers can effectively manage the risk throughout the process. With that, I'll turn things over to my colleague Stephanie to begin our first topic on procedural fairness and delay. Over to you, Stephanie.
Hello, everyone. So for those of you who attended the client seminar that we had in person in Toronto on April 28th, you may recall that I said when we were talking about investigations at that time that I could give an entire presentation on procedural fairness. And this is what we call follow through. So we're going to talk about it from a lens of what the procedural fairness rules are, and then from there, I saw when looking at today's registration list that there are a number of people that are participating from federally regulated employers. So you know we're talking about Marintet and this aberration of case law that has come out, adding a new step to procedural fairness that I fundamentally disagree with. And then we're going to bring it back to talk about timing considerations and how they impact procedural fairness and how to manage it. Okay, so we know that all employers have a general duty to investigate across Canada, whether you're provincially regulated or federally regulated, and that obligation is to protect employees from and conduct investigations into workplace harassment and violence. Now, we know that we have to do it, but how do we do it? So in Ontario, the Occupational Health and Safety Act, the OHSA, gives us the relatively useless guidance that we have to conduct an investigation that is appropriate in the circumstances. Thank you for nothing. And then under the federal regs, the workplace harassment and violence prevention regs, we have timing requirements set out in great detail, investigator knowledge and training requirements, again, set out in detail, and report content requirements with 3 headings. But there is very little on what actual process needs to be followed in terms of conducting these investigations. So there are elements of procedural fairness, and these are what guide us when we're conducting these investigations. So the rules of procedural fairness, I am going to be referring to as the cornerstone of an appropriate workplace investigation. And these are the things that we rely on in the absence of statutory guidance. And they have certain elements. The first is an unbiased and qualified investigator. The person conducting the investigation needs to not be predisposed to one side or the other and needs to know what they're doing. The second, which we'll come back to, is a timely investigation. Justice delayed is justice denied. If you don't look into something in real time, you can interfere with the effectiveness of the investigation, and we'll discuss the risks a little bit later. The other piece is opportunities for parties to present their version of events. So this includes, and it has always included, the opportunity for the complainant to provide any facts and evidence in support of their allegations, as well as the opportunity for a respondent to completely and fully respond to the allegations against them. And then at the end, once all of this has been followed through with, parties have the right to know the outcomes of the findings of an investigation and any corrective action to be taken. But those of you at federally regulated employers know that we've got this aberration that has come up in the case law that has effectively added a new step to the rules of procedural fairness. So this case law, and this is a small rant because we've got limited time, but it starts with Marintet. Marintet is a decision that came out on May 2nd, 2024. And it was somebody seeking judicial review of the decision to dismiss a complaint of workplace harassment based on an investigation report that the person bringing the review said was in breach of their rights, their procedural fairness rights. So the applicant was a CBSA agent, a Canada Border Services Agency. In Ottawa, we love our acronyms. Agent who filed a complaint alleging a pattern of workplace harassment that spanned 25 years and made seven allegations against 6 different supervisors. After an investigation was complete, the investigator provided the individual with a copy of the report, which concluded one of the alleged incidents could be construed as harassment or violence, but no preventative measures were taken and the complaint was dismissed. So the applicant then sought the full record of the investigation and in which revealed that the complainant was not provided with reports received from 4 of the 6 supervisors and witnesses or provided with a copy of the preliminary report for review or comment. So the person reviews saying that their procedural fairness was breached because they weren't given an opportunity to comment on the positions put forward by responding individuals and witnesses, and the preliminary report or findings of the investigator. So those of you who are not familiar with Marintet, take a minute to think about this. This person thinks that they, and for those of you who know Marintet, you know where this is going, but this is shocking to me, thinks that they have the right to know what everybody else has said after they've put their case forward. Well, ultimately, the federal court decided, yes, they do. And I take issue with this decision. Don't worry, there's hope for us. So the first thing that everybody knows in dealing with procedural fairness and investigations is that because of the great impact that these investigations stand to have on all involved, there is a high degree of procedural fairness owed. And this is included in Marintet. They say it includes the right to know the case to be met, and this requires the right to be given an opportunity to be informed of and respond to prejudicial statements, including contradictory statements made by witnesses arising out of the investigation. Now, you know that that is a right that goes to a respondent, but when a complainant has that right as well, so they put forward their full case, you give them their evidence, they review it, and you think, okay, they're done. Oh no, anyone who contradicts them, Marintet says, they have the right to know. And what's interesting here is CBSA had a checklist that was part of their workplace harassment and violence prevention regulations that said that as part of the checklist, a complainant had the opportunity to review the preliminary report. So when I hear this, I think don't include things in your policies that you don't need to do and create additional administrative hurdles, because this resulted in, and when they're analyzing it, the court says that this goes along with the regulatory impact statement that was made when the new regs were put in 2021. So ultimately, they agree, and they agree that the complainant had a right to see all of the other evidence that contradicted what they said, and so the duty of procedural fairness was found to be breached here, and it was sent back for redetermination with a new investigator. So we used to have put forward your version of events with all of your evidence, review what you have to say, get evidence from other people, give them the full opportunity to respond, and then the investigator does the weighing. Now we've got this additional step where the complainant has the opportunity to review everything everyone else said and take another kick at the can. There's another decision that comes out in the interim called DA. DA came out, the decision in Marintet came out before the materials were, sorry, after the materials had come out. So they only tried to make this argument in the factum, and the court dismissed it because it was raised too late. So the next time they address it is in a court case called Brown. Brown is very similar in that somebody raised procedural fairness arguments saying that they didn't have the opportunity to respond to evidence from respondents or witnesses and had no access to the preliminary report. And Brown goes a step further and says that there is a procedural fairness right, further to Marintet, that a complainant must be able to review and comment on evidence and draft findings. Now let's comment. Preliminary report doesn't say what it includes in Marintet. So draft findings, to specify that, I think the court's going further than they're supposed to. But don't worry, there's another case. It's called Cabo. It's from September of 2025. And Deputy Judge Mark Phillips comes out and says that that's not right. So the facts here are, so we know that Marintet came out May 2nd, 2024. There is an ongoing workplace investigation at a federally regulated employer, and the investigator submits their final report at the end of May. Because the Marintet decision came out, the federally regulated employer tells the employees, oh, we're going to send this to you for comment. But the investigator says, no, I did my job. I put the evidence to people. I gave them a summary of evidence to comment. I am done. They don't get further comment on my findings, my legal analysis, my recommendations. That's it. And the court agreed. And you know what? I have pom-poms in my office for this reason. Way to go, Deputy Judge Phillips. And this is the quote to take away. The case law, properly understood, is in accord with the process just as described, the requirement being that a responding party know the case to be met and that he be able to meet it. No authority has been invoked indicating that investigators' ultimate findings of fact, legal characterizations, conclusions, and recommendations are to be subject to criticism from the parties with a view to them trying to influence the outcome of the investigation. And in my view, this is the right decision. It's an unbiased investigation. When we were going through the rules, the first item of procedural fairness was an unbiased investigator. So why would parties have the opportunity after the report's been written to argue with the investigator about the findings and the substance? So that gives me hope. And it's with that we will move on to the next slide, please. So timing guidance. We know, so the first one that we heard about was unbiased investigator. The second thing was timing, a timely investigation. The Ontario Ministry of Labour has given guidance that it should be taking place within 90 days or less. And for those of you who are saying, what are you talking about? It's not in the statute. It's on the guidance on the government website. 90 days or less, unless there are compelling reasons why a longer investigation is needed, and we'll address some of those shortly. Federally, we know that we have a year unless one of the parties is absent for work more than 90 consecutive days, in which case you have until 6 months after they return to work to complete. So there's a lot of leeway here in terms of timing, but there is a little bit of guidance. Next slide, please. So what are the risks that are presented by delay, undue delay in investigating something? And the first one is the one you're always going to think about, faded memories. If something happens in September and you don't ask them until over a year later, how are people going to be able to speak to that with any kind of coherence? It's to be expected that people will remember things more closely they are to the event. So the closer you are, the better they're going to remember. And we want to keep this in mind when we're managing the process. Lost evidence. If we don't jump on it right away, documents can be lost and other items can be lost. And a witness no longer available, people retiring or, God forbid, passing away, things happening so that people that you could have spoken to if you had started earlier are no longer going to be available. Next slide, please. So the potential causes of delay, because there's a reason we're dealing with it, and one of it relates to summer. It's number 2. But the first is complex multi-party complaints. So my largest, most complex investigation involved 32 witnesses and parties. And it took well over a month to get everybody's interviews and summaries ready. So it took time. Drafting that report took time. And what we know is that we can't sacrifice thoroughness in these complex situations in the interest of time. We need to balance it and be mindful of it. But when we talk about the Ontario Ministry of Labour guidance, 90 days, unless there's a good reason otherwise, a very complex investigation with a lot of witnesses is such an explanation. That's such a good reason. Witness availability, which is where we're coming down to vacations. If you get a complaint at the beginning of summer, you're going to be mindful of the fact that people tend to go on vacation during the summer period. So you're going to reach out as soon as possible to the people involved, figure out if they're taking vacation during the next little while, and if so, when. And I'll give tips on how we handle that a little further on the next slide. Medical leaves. Now, this is one I've advised on a fair bit because it's not uncommon for someone to make a complaint and go on a medical leave. Now, I will talk about how we address that on the next slide too, but it's something we can manage in a way that is reasonable. And external factors. So delays in receiving physical evidence. One that I've dealt with recently was delay in receiving a recording. So there was a third party where a recording had taken place, and so we needed to wait for that recording for a 2-week period. And we know that recordings that are accurately and accurate and unedited can give us a really great picture of what has happened. Next slide, please. So tips for effectively managing delays for you to take away. In complex investigations, I find that the best way to go is just expectation management. You just tell people, like, this is what's happening. We have more interviews coming up, blah, 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 blah. We expect to be at a space soon to be followed to the next stage. So these are just keeping people up to date on what's happening without asking for input, because we don't want them to interfere with our process, but just keeping people up to date and managing their expectations can assist with keeping the parties at bay when it comes to a complex investigation. Witness availability. So when it's medical leaves, we're gonna follow up to see if the person is on medical leave and prevented from doing only the responsibilities of their role, but can nevertheless participate in a workplace investigation. I have a chart a questionnaire that we provide to medical practitioners. We have the employee take it to have it completed to make sure that if they are medically unavailable, they're actually medically unavailable for the purpose of the investigation, which can be very, very different from someone's substantive job responsibilities. And in the meantime, we're going to determine what steps can be taken to preserve evidence, whether that's because of a medical leave or because of a vacation. So do email inbox holds need to be placed? Do screenshots need to be taken of text? Do things like that need to happen? And in terms of external factors, there's only so much we can do to manage third parties. So we're just going to follow up with them to make sure that we can get the outstanding information or item as soon as possible. And with that, it is my pleasure to pass you over to Christina Wendell, a partner and lead of our employment and labor group in Edmonton and my co-chair of the Workplace Investigations Practice Group nationally. Over to you, Christina.
Thanks, Stephanie. Always a pleasure to listen to you present. So thanks for that insight. So I'm going to be talking about retaliation risk in the investigation process today. Next slide, please. So in terms of framing the risk, so retaliation, and we're not just talking about terminating someone who makes a complaint. As we'll see, there's some more subtle examples as well. But it is a real risk and something you have to keep in mind in workplace investigations. Those complaints about retaliation, they will have impacts on the workplace, can also result in separate complaints or claims under both human rights and occupational health and safety legislation. Both of those categories contain specific provisions against retaliation or reprisal, as it's sometimes called. You should also address retaliation. That should be addressed in workplace policies and communicated throughout the investigation process. So remind the complainant that retaliation is prohibited, and if they feel they've been retaliated, they should alert the employer, HR, whoever the right person is. Remind the witnesses of the same thing, because retaliation can also be something that witnesses experience for participating in an investigation. Remind the respondent that retaliation is prohibited. So as an employer, when you're informing complainants, witnesses, respondents about the investigation, that should be part of the standard communication that goes out to them. As an investigator, I like to address that as well in the introductory comments with the people that I'm talking to about retaliation being prohibited. And then again, when you're informing the complainant and the respondent of the outcome of the investigation, that is again something that a reminder should be given to them. Next slide, please. So what constitutes retaliation? So in its essence, it's some form of adverse treatment that's connected to the individual's participation in a complaint or investigation process. So again, complainant or witness. It also, it doesn't matter if the underlying complaint is something that was substantiated or not. So it doesn't have to be a substantiated complaint. The other thing to keep in mind is to distinguish it from where there has been a frivolous or a vexatious complaint made, because that then is something that can be subject, can and should be subject to discipline. So what we're talking about here is good faith complaints that result in some form of adverse treatment. We're not just talking about terminations or express discipline. It can be more subtle, changes to reporting structures, work location, work duties, performance improvement plans. Unfortunately, I see those coming up more often than I'd like in these types of situations. So for example, if you have a sales employee earning commissions, makes a harassment complaint about their manager then changes their commission territory, for example, gives them some less ideal, less lucrative areas. As a result, the employee then sustains a decrease in pay. That's going to be a problem. Now, it's not to say you can't make changes because you're still an employer, you're still a business, and you need to operate. But you can't make those changes because the person made a complaint. Next slide, please. So when we're talking about retaliation, it's usually a three-part test. So the first part, establishing that the employee participated in a protected activity, so either made a complaint or participated in the process. Number two, sustained some adverse action. And then number three is there's a causal connection between the activity and the adverse action. Now, one and two are usually fairly straightforward and typically easy to establish. It's number three, that causal connection, that becomes the problem. Oftentimes, the temporal proximity, you have a complaint and then you have some sort of adverse action, that is going to be a key consideration when looking at, is there enough of a connection? And in many instances, that may be enough. In some of the legislation as well, there are statutory presumptions that make it very challenging for an employer to defend retaliation complaints. So, for example, in Alberta, where I practice, the occupational health and safety legislation allows for what's called a disciplinary action complaint. So an employee can make a complaint to OH&S if they feel that they've been retaliated against for bringing in some a workplace issue. So there is a statutory presumption in those complaints in favor of the worker, whereby the disciplinary action was because they acted in compliance. So that's the starting presumption applied with what's called a DAC. I guess we like our acronyms as well. The onus then is on the employer to prove that the disciplinary action was for some other reason. And the documentation is obviously going to be key for that, but can become very challenging for employers to establish. Next slide. So types and examples. So again, the overt, the obvious ones, termination. So just by way of an example, there was one case years ago where the employer the employee had made a number of complaints. They were found to be unsubstantiated. The employer actually threatened discipline against the employee if they made any more unsubstantiated complaints. Now, again, the distinction that's important here, the complaints weren't found to be frivolous or vexatious. They were just not substantiated, although frankly, I think they should have been substantiated. They were grounded in evidence, but the employer expressly told the employee, if you make any more, you're going to be terminated. And that became a significant problem later on with some significant awards of damages. They can be subtle, so schedule changes, for example, exclusion from meetings, demeaning tasks imposed on the employee, social or interpersonal retaliation, so gossip campaigns, cold shouldering, not sure that's a real word, but I think you understand what's meant by that. Procedural, more scrutiny, like I said, performance improvement plans being put in place where they otherwise wouldn't have. All of a sudden, everything is being documented. And then systemic changes, so some changes made that are really seen as targeting the complainant's role or team. When does the risk arise? And the risk of retaliation really arises throughout the process. So at the first stages, when the complaint is filed, there can be some immediate backlash from the respondent or management. During the investigation process, there can be some pressure placed on the complainants or witnesses, leaks of information. After the investigation, even regardless of the outcome, there can be some risks there. Of course, if there is a finding against the respondent where the complaint is substantiated, that's going to create a heightened risk of retaliation if the respondent remains in the workplace. And then as well, if there's some sort of external filing, so human rights or OHS, obviously that is going to give rise to escalating tensions as well. So next slide, please. What can employers do about it? So employers have a proactive duty to prevent retaliation. They can't simply wait for a complaint to arise. So again, make sure you have the anti-retaliation policies in place. Those are clear, communicated, and enforced. Remind the participants in the investigation process of those anti-retaliation policies in place and respond promptly when there is some sort of retaliation, either reported or even suspected. Interim protective measures. So, some of the usual things that you would do when you first get a complaint, you separate the parties, change reporting structures, check in regularly, and then document all post-complaint employment decisions affecting those who were involved. So again, it's not to say that you can't take action, but you do have to tread carefully and make sure that you have the documentation to back it up if there is a complaint and you are put to that onus of proof. Next slide. Consequences of retaliation. So many instances where there is retaliation in the workplace, it's not just an internal issue. It can result in some external remedies as well. So for instance, many instances where there's a complaint made internally, for instance, a sexual harassment complaint or discrimination complaint, that can also end up in a human rights complaint. So in those provisions, human rights legislation across the country has specific protections against retaliation in relation to the human rights complaint. But what's important to note is it's not like they're interpreted fairly broadly from the cases I have looked at. So it's not necessarily that the employee has actually filed a complaint and that complaint is going on. Different language in the legislation, but generally it's enough that the employee could have filed a complaint. It's okay if they haven't actually gone through and filed it. So a few cases I'm just going to talk about in the human rights kind of retaliation sphere, as those provide some interesting examples for employers of what not to do. There was one in BC in 2021 called the Sales Associate and Aurora Biomed. So again, this is a BC human rights case of retaliation. In this instance, after the CEO and founder made some inappropriate comments to an employee about her appearance, suggesting that she should wear a bikini to a conference, for example, she complained to her boss, who just happened to be the CEO's daughter. And unfortunately, the response there was really to go into self-preservation mode. Eventually, they terminated the employee. There was a dispute about some commissions owing. The employer offered to pay the employee those commissions, but in exchange, they wanted her to sign a statement where she said she had made false accusations and was dismissed because of her poor performance. Not surprisingly, she refused to sign that and then ended up filing a human rights complaint. The Human Rights Tribunal found that the termination was retaliation under the code. It didn't matter that the employee hadn't threatened to make a human rights complaint. So that was one of the arguments made by the employer. Well, she hadn't mentioned anything about going to the human rights to make a complaint. They weren't even specifically aware that that was an option for her. But that didn't matter. The fact is she could have gone and that was an avenue for her. And obviously she did eventually go there. So in terms of human rights remedies, general damages are a common component as well as lost wages, and reinstatement is a possible remedy, not one that we see very often. So in that sales associate case, because that was anonymized, she ended up getting a job fairly quickly after, so there wasn't a lot of lost wages. The general damages they awarded to her, to give you an idea, was $20,000, which seems kind of low, although I suspect those have been an increase since 2021 in BC. Certainly they have in Alberta. There was a 2024 case in Alberta that really set the high mark of $75,000 for those general damages. That was obviously a very serious case with sexual harassment involved. But in that case as well, the individual respondent had retaliated against the complainants very overtly, I would say. He filed statements of claim against the respondents, alleging that they had caused him damages by filing the human rights complaint. So not surprisingly, the Human Rights Tribunal in that case found that that was retaliatory and contrary to the code provisions for Alberta. And they awarded, so in addition to the 75,000 general damages for the regular discrimination, if you will, they awarded an additional $50,000 to one of the complainants for two statements of claim that the respondent had filed against them, and $25,000 for another complainant who also had a statement of claim filed against them. So as you can see, those can be quite significant. If there's a retaliation at the workplace, the employee ends up being dismissed or constructively dismissed. That can result in a court claim, wrongful dismissal or constructive dismissal claims. So there's some exposure there to punitive, aggravated moral damages and extended notice periods. Those are, again, regularly increasing in the amounts that are being awarded. Occupational health and safety remedies. As I noted, in Alberta, there's disciplinary action complaints, or DACs, that may result in remedies for lost wages, reinstatement. Similar provisions in other jurisdictions as well. So just by way of a quick example, and I didn't include the sites, but I can add the sites when the slides are circulated, so you can review those in some more detail if you're interested. But in this one from 2005, it's called Velasquez and Integrity Building Concepts. So this was a DAC complaint that was appealed. So the appeal body for those is the Alberta Labor Relations Board. That one started with a harassment complaint made to HR. It was investigated, found not to be substantiated. A couple weeks later, the employee makes another complaint. In the course of that investigation, the employer made some comments to the employee that if he didn't speed up or improve his performance, he was at risk of termination. There was a witness who also made some complaints about the employee's performance. A few days later, the investigation was complete. The employer determined that the complaint was not substantiated again. And later that day, the employee was terminated. So the timing is obviously suspect. Now, the employer claimed that it was a performance-related termination. The employee was still in their probationary period, and that's what they relied on. Now, at the initial level, so the DAC initially goes to an occupational health and safety officer who reviews the matter, issues a report. The officer actually found that the employer had provided enough supporting information to rebut the presumption that the termination was unrelated to the complaints, but was instead because of the work performance. So on appeal, the Labor Relations Board disagreed, noting that those performance issues, the only time they had been raised was in the context of the investigation. So they weren't able to separate it out from that investigation, from the complaint, and ultimately the retaliation. There was no record of any sort of performance concerns, anything being raised with him prior to that. So it went actually back to the officer for reconsideration. Just the last one I want to talk about really quickly is, again, a very recent one from 2025 out of Ontario, Braganza and Randstad Canada. Again, that's a reprisal complaint under the Ontario Occupational Health and Safety legislation. So that case involved a manager who had made complaints against her coworkers who were playing a vulgar party game in a couple separate incidents, once at a corporate meeting, once on a work retreat. So the employer in that case, they retained an external third-party investigator. The investigation actually found that there were components of the complaint that was substantiated. There were violations of the respectful workplace policy established. The complainant went on medical leave. Before returning to work, they expressed some concerns to HR about possible retaliation, reprisals. They actually asked for a transfer, but HR wasn't able to do that because, according to them, there was no room elsewhere. Then there was an issue where the complainant's peers, a number of her peers, were promoted, and in the end result, she ended up reporting to someone who had previously been one of her peers. She also had some restructuring in her position, ended up losing clients, thus losing money. And then a few months later, she was ultimately terminated with the employer citing organizational changes. The board, when considering the complaint of reprisal, noted that the employer had basically a lack of any documents to substantiate the claims that she was selected for termination because she was a poor performer. They were also not impressed with the changing stories. So initially, the employer said, well, it's an organizational change. And then when responding to the complaint, the employer was raising performance issues as being the reason for the termination. So their story changed, which the board was not impressed with. The board acknowledged it could be a poor employee, but that wasn't the issue. As long as the complaint, the investigation was one factor, even though she may have been a poor employee and there was performance issues, the employer in that case was unable to justify the termination. The judge or the board there referred to the case being tainted by the animus of the complaint. The reputational risk, obviously, these decisions end up being public most of the time, so can result in some media attention, employee morale impact as well. Personal liability, so in a couple of the cases I just talked about, it was individual respondents who were named in the complaints as well. Next slide. So just some takeaways. When looking at a complaint, consider what's behind it, even though it hasn't been substantiated. So just because the finding is, well, this wasn't a breach of the policy, doesn't mean that there isn't something going on that you should be looking at as the employer. You know, is there some sort of personality issues? Is there something that can be fixed? So something to think about there, or else the issues are going to continue coming up. Implement, communicate retaliation policies throughout the investigation process. Make sure your managers are trained on how to handle those complaints and what constitutes retaliation, particularly those subtle forms. Changing structures, changing roles, changing duties. Those can become problematic as well. Obviously, you want to be cautious, extra cautious and wary when the complaint is made against the manager, which is the last point there. Ensure some separation of the decision-making for the people that are involved in the complaint process. And then it's the second last one, but probably the most important one, is document and monitor all employment decisions affecting those who were part of the investigation process for a period of time. I mean, how long a reasonable time? 6 months to a year. Like, it's that temporal proximity that can be very damning when you're taking steps against an employee. Again, it's not to say that your hands are tied and you can't take action against someone because they've been involved in a complaint. You just have to make sure you're not doing it because of their involvement in the complaint and that you can prove that. So, for instance, if you've never put in place a PIP, a performance improvement plan, and all of a sudden you're doing it shortly after a complaint's been concluded, that's going to look problematic. So just tread carefully. Don't terminate employees the same day that the complaint is wrapped up. Don't threaten to terminate employees when they file a complaint. And with that, I'm going to move from, I guess, employers behaving badly to employees behaving badly, and my colleague Eleni.
Hello, everyone. Good morning or good afternoon, depending on where you're situated. I'm on the West Coast, so I'm still at 9 o'clock in the morning or almost 10 o'clock in the morning. So I'm going to talk about what happens, I guess, the morning after people have gone out together that work together or a work-related matter. It's a big problem for employers and it remains an issue as event season kind of ramps up. So summer is a bit of an event season. Christmas is a minefield of an event season. Those types of periods where you're trying to control what your employees are doing to make sure that liability is minimized, but it's not always possible. So let's get into it. If we can go to the next slide, please. So if something happens at a work-related event, and we'll talk a little bit about what that is, you have to consider whether there's a duty to investigate. So of course, your policies will determine a lot about whether or not you need to investigate, but there's often legal implications as to whether or not you're required to investigate. If you're dealing with a workers' compensation type matter, allegation of mental distress in the workplace, or some kind of toxic workplace, or bullying and harassment in the workplace, your legislation across the country relating to requirements imposed by occupational health and safety regulations or workers' compensation legislation may well require an investigation. Your policies probably speak to off-duty conduct. I've revised dozens of codes of conduct and respectful workplace policies to incorporate the concept of your behavior outside of work is also something the company can take steps to remedy. Your IT policies and social media policies do or should cover, in explicit terms, appropriate versus inappropriate uses of those platforms, especially if you're representing yourself as a member of the company. Even though you're saying I'm acting in a personal capacity, on LinkedIn, everybody knows who you work for. On other social media platforms, everyone knows who you work for. And it's important for the company to create parameters around what's appropriate when employees are using social media and publicly making statements that could be harmful to the company. So in most cases, it will either be obvious that an investigation is needed, or it's going to be obvious that you don't need an investigation. Some acts of misconduct off the job make it very clear that you should fire someone, for example, and that will reset the workplace and make everything okay. But in most cases, you probably need to consider whether or not you should investigate. And in most cases, you will need to investigate if the workplace is implicated in even a small amount, or the company's reputation could be impacted even a small amount. You probably need to look into it. You probably need to investigate. Next slide, please. So what's the workplace? It's very large. So it's anywhere that work's performed. There's office environments, there's client sites, remote workplaces, the home office, places where meetings are held, work-related trips, events, conferences, trade shows, social events, people's vehicles when they're engaged in work, online communications, text, chat groups. You do have a circumstance now especially with hybrid work, where a lot of communications are done via text, via instant messaging, via Slack, via Instagram even. And that can be a problem because when people are communicating outside of formal processes, they become less formal, and that can trigger implications, especially for bullying and harassment type issues, which we see quite a lot in the electronic world. Next slide, please. But there is a difference between what's off-duty and what's the workplace. So off-duty conduct refers to an employee's behavior outside of working hours, and that can be independently actionable. So there's the work-related events that can be actionable or require investigation, but there's also the off-duty conduct that can be actionable by the employer or require investigation. So generally speaking, you can't discipline employees for their off-duty actions unless there's a clear nexus or material connection between the conduct and the workplace, such as severe reputational damage, compromised job performance, or safety concerns relating to the workplace. So I'll give you an example. In 2011, in BC, we had some riots following the Stanley Cup loss of the Canucks. Not a big surprise that they lost, but here we are. And people that were caught on video, and it usually went viral, smashing properties, stealing from stores. That was harmful to the employer's reputation, and a bunch of those people got fired. And guess what? none of the employers had to pay those people any money because the nexus was well established. Um, conversely, I get calls all the time. Our our colleague was seen at a protest. We don't, it doesn't sit right with us. We don't, we're not MAGA, we're not whatever we are. Um, and then I have to say, well, that doesn't harm the company's reputation. That's not something that is actionable. In some cases, some protests, of course, can escalate in the wrong way, and then depending on what the person does, that can be actionable. But for the most part, in BC, political belief is a protected ground under the human rights legislation. You can't discipline someone for going to a protest. So it has to have a nexus to the company's operations, reputational harm, the individual's job performance, some kind of severe implication to the workplace. And then you have the problem with social media. So I've kind of alluded to it already, but the line between personal and professional lives has been blurred for over 20 years with respect to social media, and it appears to be getting worse. So offensive online comments or controversial political posts, like if you said something that, would incite violence, but it's rooted in a political belief, that would be different than just going to a protest and could be actionable. So you have to sort of gauge what is legitimate disciplinary action. And we have quite a few cases where when that conduct has sort of seeped into the workplace, whether or not, your other colleagues or your other coworkers feel threatened or feel that they're being bullied and harassed by this conduct, then you can actually discipline for that kind of free speech, so to speak. So if we can go to the next slide, I just put a selection of a few cases that speak to these issues. The Metrolinx case is a very recent case where the Court of Appeal upheld the dismissal of a group of employees that were basically sexually harassing someone else that worked with them and making derogatory comments about them in a private WhatsApp group. So this is a group of friends that all work together, sexually harassing basically this other employee, and they were properly dismissed for that conduct. In a case for British Columbia, the Menere case from a couple years ago now, that employee was involved in a motor vehicle accident completely outside of the scope of work with a cyclist, but he couldn't just have an accident, exchange insurance information, and go from there. He decided to have an altercation with this cyclist and subsequently posted dash cam footage of the accident onto his social media. And the employer asked him to take it down, to delete it. He refused, but his social media identified the workplace, and the social media posts were going to be damaging to the employer's reputation because this person was like a quasi officer of this society that did enforcement of cruelty to animals type conduct. So they made a case that no, we have cause to terminate, and that worked. And then the final case is a much older case, the Lougheed Imports case. And I remembered it when I was preparing these slides because there was like a flurry of activity when this case came out in 2010. And it required all of us to go to all of our clients and say, we have to revise your policies, because this was a case before any policies actually said, be careful how you use social media, be careful how you are in your off-duty life, because it could impact the workplace and you could get fired. And in this particular case, there were no policies, but the employer was still successful in terminating for cause based on threatening, derogatory comments about the employer, allegations on Facebook about wrongdoing by management, those types of things. So the moral of the story on these cases is your quote unquote off-duty conduct or conduct you think is private when you're using social media can still get you in trouble. And with that, I wanted to go to a couple of case studies because knowing that you can discipline someone, is different than how do you get there. And the first case study gives us the very difficult example of when non-parties to your company are also involved in the misconduct. So it's case study number one. It's Monday after a conference where almost your whole sales team attended for networking purposes. It was the industry event of the year, and many clients of the company attend. So Stephanie comes to you as I didn't even think of it. I didn't even think of it that one of our speakers was Stephanie when I use these names. Sorry. Stephanie comes to you as Director HR and tells you that at the after party following the formal dinner on Saturday night, the VP sales of your company and the director of sales of one of the company's largest clients were making sexually charged comments about some of the women attending the conference and how they looked outside of work. Later that night, they went with a few other employees from both companies to a strip club. Stephanie does not know what happened next as she went back to her hotel room, but at the airport the next day, one of the client's employees who had gone to the club with the others looked like she had been crying as she got on a plane. I'm going to tell you very clearly that I wish I wasn't still advising clients about the aftermath of employees going to a strip club, but it still happens. It's been happening my entire career, and I can't believe that it still happens. So I decided to use that kind of issue as a example. So here, the big issue is, do you have to investigate? I would say yes. This was a work related event. This is attended by a group of your employees. The sexually charged comments is directly implicated under a number of pieces of legislation that would require investigation. But how do you go about also investigating your client? And that is, a bit of a minefield because you don't want to damage the client relationship. You probably need some kind of plan on how you can approach your contacts at the client and say, we understand some stuff went down. Probably someone's complained to the client from the client about the same conduct. So there is a universe where you can get aligned on what to do next. Of course, you can't breach confidentiality or do too much vis-a-vis the client, but there is an obligation under legislation to investigate, even if it's involving third parties that are not necessarily in your control. And if they refuse to be interviewed or there's a refusal to cooperate, you have to still try. And if it doesn't work, that's manageable in a different way with your investigator. But you still have to try because the obligation to create a safe workplace includes when third parties are involved. So this situation requires looking into. It may not require discipline. Nobody knows. It sounds like some stuff happened. Unfortunately, you're going to have to use resources to figure out what went down. So if we go to case study number 2, I'll try to go quickly. This is ripped from the headlines, but I'm not going to tell you where I ripped it from. If you know, you know. You wake up and you have a bunch of emails about a viral TikTok involving the CFO. It wasn't a CFO in real life of your firm. The TikTok provides details of a war of words and private messaging between a TikToker and your employee. And it culminated in your employee referring to the TikToker in derogatory terms. And the post states that your CFO has been bullying and harassing subordinates for years, and the firm is doing nothing about the toxic workplace. By the time you arrive at work, others have already sort of gone into it with this particular CFO. And he says that it was a private conversation and it's none of the firm's business. And then he says he was drunk and likely needs to go to rehab. So we often see the, it's not my fault kind of, I'm sick. And that's because they're trying to trigger accommodations and stave off termination. So is there a duty to accommodate? Maybe, but your immediate duty is, do we need to investigate or not? And if there's actually some kind of foundation to this comment on the post that it's a toxic workplace and he's been bullying his subordinates for years, then I would say, yes, you have to investigate. If there's no foundation to that, then I would say you don't have to investigate and you can just move straight to discipline based on the harm to the reputation of the company vis-a-vis the CFO. And then, of course, you need some legal advice about the human rights aspect and whether you need to accommodate him. I will say that in real life, there was a number of comments on the TikTok that said, I work with this person, anonymous comments. I work with this person, and yes, I have suffered the same type of conduct. And there were a few of those. And that did result in the real life company launching an investigation because they were worried about toxic workplace, psychological harm in the workplace, and whether or not they had a bully on their hands. So just quickly, because I know we're running out of time, I can wrap up with some key takeaways. So it's important to ensure that your policies address this off-duty conduct explicitly. People are largely naive about what is appropriate and not appropriate. A lot of people think they just know. I don't think an employer can take for granted that their employees just know what's right and what's wrong, or that they're going to be showing good judgment if they're at events. So warn them, warn them explicitly. And if they know that their conduct can be investigated and can impact their employment, they're more likely to fall into line and do appropriate things as opposed to inappropriate things. I would say you conduct your normal training for respectful workplace, but make sure that you're also incorporating comments and training regarding work-sponsored or related after-hours activities and proper use of social media. I think it's important to also express limits on what the company will pay for. A million years ago, one of my clients had a problem with the strip club example. And I learned through that they were reimbursing people for taking clients or people after work for drinks, regardless of location. And I'm like, you can make rules about that, So they banned being able to get reimbursed for those types of activities. And you can do that and incorporate restrictions on what can be expensed and what can be expensed. And then guess what? If you don't get reimbursed, you're unlikely to take 7 people to the strip club. And you can limit after parties and that type of conduct because really the party is enough. You don't actually need to pay for the after party as well. Consider a protocol for managing investigations and remedial actions where third parties outside the investigation may be involved in any misconduct. So as part of your investigation processes, you can have, a decision tree. Okay, this third party is involved. Who is our main contact over there? And how can we approach them to make this go smoothly and maintain our good relationship with them? Is it so scandalous or potentially scandalous that we should be hiring an external investigator to create distance between us and the client with respect to making sure that they don't blame us for the outcome of the investigation, and we can sort of have that discussion with the client about why we're approaching it a certain way to try to maintain good relations. So, investigations are not simple. It's actually, they can be very complicated, and having sort of this issue in mind, if third parties are involved, that could also impact the business if the investigation is not handled delicately is part of your planning as well, is my view on that. And with that, I'm done.
All right, thank you, Eleni. Some very great insights from all 3 of our panelists. If you have any follow-up questions or if you'd like some tailored guidance on any of the issues we discussed today, please don't hesitate to reach out to any of our panelists or any of the team at Dentons Canada. Thank you, everyone, for your time and engagement today, and we look forward to connecting with you again soon. Thank you.